The Law of Self-Defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Welcome to our live coverage of Day 5 of the trial of former police officer Derek Chauvin over the in-custody death of George Floyd. I'll be live blocking the court's proceedings all day in real time. For those who may not know, I'm Attorney Andrew Branca, an internationally recognized expert in use of force law, providing daily real-time legal analysis of the Chauvin trial's proceedings as a guest commentator for Legal Insurrection, as well as over at my own blog at Law of Self-Defense, lawofselfdefense.com. Today's content is sponsored by CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. CCW Safe, in effect, promises to pay their members legal expenses if their member is involved in a use of force event, and those expenses start big and get bigger fast, folks. A typical aggravated assault charge, which can happen if you simply point your gun at another person in self-defense, don't fire a shot, don't hurt anybody, can risk a 10 or 20-year felony sentence and cost as much as $30,000 to $50,000 in legal fees to defend, and that's just for the pre-trial expense. If you don't have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family, it can be useful to have a financial partner standing behind you to make sure you have the legal resources you need to fight the legal battle the way you'd want it fought. Now, I've looked at all these types of services you might imagine, and I found that CCW Safe is the best fit for me. I'm a member. My wife, Emily, is a member. Whether they're the best fit for you is something only you can decide, but I do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member of CCW Safe, you can save 10% off your membership at that URL, lawofselfdefense.com/CCW Safe, using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. Anyone interested in a free podcast version of our daily legal commentary and analysis of the Chauvin trial, you can find that available at the Law of Self-Defense News and Q&A podcast, available on most every podcast platform, including Pandora, iHeart, Spotify, Apple Podcasts, Google Podcasts, or you can just get an RSS feed for whatever podcast player you use. You can get all of that information at lawofselfdefense.com/free podcast. We're now entering the second full week of the state's prosecution, presenting its case in chief, where it is to meet its burden to prove Chauvin guilty of the crimes charged and to do so beyond a reasonable doubt. The first week consisted largely of the emotional, often weeping and sobbing testimony of bystander witnesses who necessarily saw only a small portion of the officer's interaction with Floyd, had only limited understanding of what was going on, and lacked vitally important facts about what the officers were doing to try to save Floyd's life, including having made a Code 3 lights and sirens emergency call for paramedics who were en route to the scene. This was followed by the testimony of several Minneapolis Police Department officers who had negative things to say about Chauvin and his purported conduct, but whom similarly had knowledge of only a fraction of the relevant facts surrounding the officer's interaction with Floyd, as well as evidence-supported alternative explanations for Floyd's death other than Chauvin's knee. Indeed, so far we've seen no testimony from state's witnesses as to precisely how it is supposed to be that Chauvin caused Floyd's death, or even contributed to that death in a wrongful manner. So this week I'm hoping the state will finally begin to share with us their evidence on the three core issues in this case. However rarely stated, those issues may be stated in the media. For example, first, what killed Floyd? Was Floyd killed by mechanical asphyxia, by the officers compressing his chest and neck to such a degree that they effectively and intentionally murdered Floyd on a public street in front of a crowd filming them? This seems to be unlikely to be the state's theory of the case, as not even the state has charged Chauvin with a crime based on intentional killing. Alternatively, did the officers kill Floyd by mechanical asphyxia but unintentionally, in a manner showing such indifference to a known risk of death or serious bodily injury that their conduct, even if unintentional, constitutes criminal recklessness, which could, in theory, be the basis for the charges against Chauvin? If so, what's that mean for the accessory charges against the other officers? Were they accessories to an act of criminal recklessness? Is that even possible, legally speaking, to be an accessory to something unintentional? Again, whatever the state's theory, they must prove it beyond a reasonable doubt in the face of evidence-based alternative explanations for Floyd's death, including his threefold fatal levels of fentanyl, presumably the result of his attempt to hide his illicit stash of fentanyl methamphetamine pills via rapid ingestion when approached by police, his existing severe hypertensive and cardiovascular disease, his history of prior overdoses on similar drugs with similar physiological effects on his body, and his decision, despite his frail and overdose condition, to fight lawful arrest against multiple officers for a full 10 minutes. All of this in the context of the lack of any physiological evidence of mechanical asphyxiation, including a lack of any signs of trauma to Floyd's neck. A second issue was Chauvin's conduct, even if it was deadly, wrongful. Even if we set aside the first question and presume that it was Chauvin's knee that was a causal factor in Floyd's death, we also need to ask the second question, which is whether the use of that knee in that manner under those circumstances was wrongful or lawful. The Minneapolis Police Department use of force policies in effect at the time explicitly permitted a knee-on-neck restraint technique when dealing with non-compliant suspects. Indeed, MPD training manuals on restraint included illustrative photographs showing the precise technique used by Chauvin. Further, officers are not only permitted but required to use force, not only to protect themselves and the public, but to protect the in-custody suspect even from himself. To the extent the officers believe Floyd was suffering from excited delirium, and we know they were concerned about it because they are heard discussing this concern on their body-worn camera footage, the standard protocol is to completely restrain the suspect's entire body to prevent the overexertion believed to kill in cases of excited delirium. Further, it's well recognized that overdose victims who regain consciousness often immediately respond with violence when they rouse, and thus steps to prevent this would be reasonable. This is all the more the case when the suspect is being restrained on the street in one of the busiest intersections of the city with moving traffic mere feet away. All of these are factors that could make Chauvin's knee-on-neck restraint of Floyd entirely justified under the totality of the circumstances, and thus not the basis for criminal sanction, even if it did contribute to Floyd's death. After all, a patient who dies on a surgeon's table dies at least in part because the surgery has opened them up. But we don't put that surgeon in prison simply because his conduct contributed in some manner to the patient's death because the surgeon's conduct itself was lawful. A third issue. Was there a criminal delay in providing care? This is a third potential theory of criminal liability on the part of the officers. It could be that there was a criminally reckless delay in providing apparently necessary care to Floyd. This was hinted at by some testimony last week. Paramedic Smith, for example, expressed the opinion that the officers could have begun chest compressions before his ambulance arrived on scene. Now, I'll note that delay of care was not the purported criminal misconduct laid out by Prosecutor Blackwell in his opening statement. Rather, the claim basis for criminal liability was mechanical asphyxiation, a completely different theory of the case. Is the state changing its theory mid-trial? If so, why? I mean, we may not know all the evidence the state will present in its case in chief because that presentation is still occurring, but certainly the state knows what evidence it will be presenting. Should we not expect the state's case in chief to be internally coherent? Further, the question of delay in care is impossible to assess without taking into consideration all of the surrounding circumstances, including the officer's awareness that they'd already made a call, Code 3, emergency lights and sirens, medical call, as well as the growing angry mob threatening imminent physical violence, to the point that Officer Tao was physically restraining the mob, that both Tao and Chauvin were reaching for their OC canisters, and now we've even heard testimony from the state's witness, the store clerk, that he himself was obliged to physically restrain others in the mob. Also a factor here is the danger that the 6'6", 230-pound Floyd, if resuscitated, might be immediately physically violent. The soon-to-arrive EMS had the powerful sedative ketamine on board, a drug routinely used in such circumstances to protect not just the officers from the suspect, but also the suspect from the suspect. The officers had no such means at their disposal. Even in the state's opening statement by Prosecutor Blackwell, in which they are supposed to set out a broad view of their theory of Chauvin's criminal liability, there was a great deal of emotive hand-waving and half-truths in the form of context-less citations of selected portions, but only selected portions of the MPD policy manual, and a complete lack of any consideration of how the state intended to overcome Chauvin's likely defenses. That is, that his conduct towards Floyd, first, wasn't the cause of death, given the overdose and other facts, and second, even if a cause of death, was nevertheless justified under the circumstances. Again, the state will be obliged to make its case and overcome these likely defenses beyond a reasonable doubt. So here's hoping that this week we see the state either make progress in meeting this burden or alternatively expose a central weakness in their case in chief. Meanwhile, we'll continue live blogging today's proceedings in court as we have been doing since the start of jury selection and providing commentary and analysis of these proceedings in our separate wrap-up posts after the court has adjourned for the day. So until that next post, folks, the wrap-up post for today, Monday, April 5th, the 6th day of trial proper for Derek Chauvin. I'm Attorney Andrew Branca for Law Self Defense, providing guest commentary and analysis for Legal Insurrection. Stay safe.